Good afternoon, morning, everyone, and welcome to the Ballard Spahr Dodd-Frank Task Force presentation webinar on executive compensation and corporate governance. This is the second in a series of webinars that we've hosted since the passage of Dodd-Frank following our CLE for free at the end of July. The first webinar was last week, and it was on federal preemption issues. Just to give you some information for upcoming webinars, on October 6th, we will be hosting a webinar at the same time on Consumer Financial Protection Bureau issues. And then on October 20th, have a webinar presentation on some whistleblower incentive provisions of the Dodd-Frank Act. My name is Mary Mullany, and I'm joined by my colleagues Justin Klein and Jeff Buchanan. And our focus for this hour is going to be on the executive compensation and corporate governance provisions of Dodd-Frank to help everyone understand what the requirements are and when they're going to start impacting you. So I will turn this over to Justin Klein, who's going to talk first about some of the say-on-pay and golden parachute provisions of the Act. Justin?
Thank you, Marie. Good afternoon, good morning, everyone. We're delighted that you've joined us for this hour session on executive comp and corporate governance. As Mary said, I'm going to talk about the say-on-pay provisions and the golden parachute provisions, both of which involve non-binding advisory shareholder votes. That is, that these votes are required, but they are advisory only. They are non-binding, but they often can send a very, very strong message. First, with respect to say-on-pay, as I said, this is a non-binding shareholder vote. It will be in the proxy materials, and it will be a vote on compensation paid to named executive officers who were disclosed in response to Item 402 of Regulation SK. It is required for all companies that have meetings after January 21, 2011, and so it's probably going to cover the vast majority of public companies. The vote must be taken once every 3 years, and there is a separate shareholder vote on how often a on-pay shareholder vote should take place. And every 6 years, shareholders are required to vote on the frequency of the vote. C is authorized to adopt rules and take actions. Obviously, they have broad authority, but in their authority, they certainly can't change the effective date, and this is really reality for the 2011 proxy season. The SEC does have the authority to exempt classes of issuers, as noted in the slides here, and it's conceivable that they would look at this and they might say smaller reporting companies are exempt from this or exempt for a period of years. I guess I would point out that there is precedent for this already. The TARP recipients, those financial institutions that received money in the past year or so, were required to have say-on-pay advisory votes in their proxy statements. And then there were also a number of non-TARP companies that also had say-on-pay proposals in their proxy statements. In 2010, there were approximately 80 companies that these votes, and in 2009 there were only 19. But clearly, you can see the trend increasing. Obviously, with this new proxy requirement, there are issues to consider, and obviously the primary one would be to look at the CDNA disclosure and to make sure that it adequately describes the analysis of the compensation committee. And I guess one of the things that we've been telling clients is it's really to have sort of a fresh set of eyes look at the CDNA and really ask the probe questions as to whether or not it adequately explains how and why a particular compensation is paid, because essentially you're going to be asking the shareholders to vote on this. Mentioned at the outset, it is non-binding. However, a no vote certainly sends a very strong message to companies. And the United Kingdom has had this requirement in since 2003, and a lot of the companies that received no votes really ended up engaging in a dialogue with their shareholders to identify what the problems are. And I would also add that there's a terrific article in the Corporate Council in the and August issue of 2010, which describes really what shareholder engagement is all about. And I will refer you to the article, but I will touch on a couple of the points that are made in the article. Essentially set out a roadmap as to how to engage with your shareholders over compensation issues. And obviously, the first thing to do is to really identify who are your shareholders and identify whether or not they have particular views or practices with respect to compensation matters. Also to look at their proxy advisors to figure out whether or not they are taking positions with respect to compensation. And it's also useful to look at those shareholders and see whether or not they've deviated from the recommendations of their advisors. The second important point they raise is really who is the company's spokesman with respect to compensation matters. The CEO and the CFO, while they are often the lead spokespersons for the company, in the instance of compensation, since the shareholders are voting on their compensation, they may not be the best candidates to be the company spokesperson on that. And then often you find that the chief governance officer or an investor relations person could become the spokesman with respect to compensation and governance matters. The question comes up as to when shareholders should be engaged, and I think that based on all of the changes that we're seeing, it's really become sort of a year-round event. It's not just an event that takes place at proxy solicitation time. Another point about shareholder engagement is how you actually do it. And there are suggestions out there that surveys can be done. There can be group meetings with shareholders. There are often one-on-one meetings, although I would caution that to the extent that you have one-on-one meetings, there are Regulation FD concerns, so you should just be mindful that once meetings take place, you enter into a confidentiality agreement or be analyzed whether or not the information that you're sharing is particularly material or not. And that's the last point really, is to the extent that shareholder concerns are articulated, how are they being addressed? What changes are being made, and how are they actually being implemented? But I would just really reiterate that this article in the Corporate Council is really very good, and it really does present a very good roadmap. A question of how often you should have a say on pay shareholder vote. As I mentioned, you're required to do it once every 3 years, and the shareholders will decide whether they want it every 1, 2, or 3 years. There's some thinking out there that it really just ought to be done annually. It will become reasonably routine just as ratifying the choice of auditors has become reasonably routine and won't really create a whole lot of noise out there. But in deciding whether decide the interval for the vote, you may want to look at whether or not your executive team is turning over, whether or not you have a staggered board, what the stagger is. So, for example, if you have a staggered board that elects one class of directors every 3 years, you don't necessarily want to go to a 3 say on pay vote, because each time voting on say on pay, you'll have those same directors coming up. Those are just some of the considerations. Issues to consider are look at prior shareholder proposals. What was the outcome? Look at whether or not the company has committed to any say on pay vote process. Another issue is the impact on smaller reporting companies. As you know, no CDNA is required for smaller reporting companies, but if they decide to have CDNA, they need to fully comply. As I mentioned at the outset, it's conceivable that the SEC will either exempt or delay some of the smaller reporting companies from the say on pay advisory vote. Just turning to golden parachutes for a few minutes. I mentioned at the outset that there's also an advisory non-binding vote with respect to golden parachutes, and the requirement is that if you have a proxy or an information statement that seeks approval of an acquisition, merger, consolidation, etc., there must be a separate vote on the NEO executive comp related to the transaction with the acquiring entity or the issuer. This, as you would expect, covers all compensation, present compensation, deferred, and contingent compensation. The resolution must cover the approval of the arrangements and the aggregate total of compensation that may be paid or become payable to each NEO. And the company, at the time that they're seeking their non-binding vote on golden parachutes, not yet had a separate say on pay vote. You must include a separate say on pay vote in that proxy statement as well. A slide indicates this is also effective in January 2011. You can expect some information coming out of the SEC. The SEC obviously will come up the rules that frame the disclosure obligations, and then also the SEC has exemptive powers. Issues to be considered for this golden parachute vote, as I mentioned, if the company has not say on pay vote, then it must do that, and that also must be included in the merger proxy. It's a good time to review change in control agreements, because those agreements will tell you what the golden parachute payments will look like. It's also a good time just to review the disclosure they have on termination of employment provisions that are contained in historic proxy statements. And if the company is completing changes to its post-employment compensation arrangements, you consider whether to add a say on pay vote to a proxy statement before a merger proxy is needed. I mean, this really will get one of those votes out of the way before you actually need to take it. Then the slide that I will talk about, which I think is really a very important one because it contains some legal considerations, is this slide entitled Rules of Construction. And I think the point here is that these advisory votes can't be construed as overruling a decision made by a company or a company board. Second, does not create or imply a change to fiduciary duties. It does create or imply additional fiduciary duties. And it does restrict or limit shareholders' right to submit compensation proposals. As I said, I think that those are very important legal considerations for for everyone to be aware about. And then this is also a very important, a little bit of sleeper change in here, that every institutional investment manager subject to 13F reporting must report annually on how it voted. That is a new requirement. I think it is going to become a very significant one, and we just wanted you to be aware of it. And with that, I'll turn the program over to Jeff.
Justin. All right, I'm going to discuss the new compensation committee independence requirements. So under the Act, the SEC is required to issue rules that prohibit the listing of a company on exchange if the compensation committee does not satisfy certain independence requirements with regard to itself and with regards to the compensation a consultant hires. So let's address the requirements relating to the compensation committee. As a starting point, men will be subject to independent standards that likely will be similar to audit committees. On New York Stock Exchange and NASDAQ already have a kind of independent standard for compensation committees. New rules are going to be tougher. For example, the key members will not be able to earn compensation from the company beyond address fees and must have no other affiliation with the company or its affiliates. Thus, in advance of the actual rules, companies really should begin looking at the compensation committee members and their relationships with the company. Like, for example, in a venture-backed company that has gone public in which the VC still owns shares, an employee of the venture fund who is still on the board may be considered to have an affiliate, just as one example. To address the requirements relating to the compensation consultant. The first requirement is the consultant must be retained and compensated by the compensation. In the compensation committee must consider the independence of compensation advisors and provide enhanced disclosure of any conflicts. Rules thus add requirements beyond the recently effective proxy enhancement disclosure rules. Required information regarding the identity and fees of the compensation consultant. We'll need to wait for the SEC to issue its rules regarding these new disclosure requirements on the independence of advisors. The Act already does provide some guidance. Here's a list of 5 enumerated considerations, some of which go to the consulting company that employs the individual advisor, and some of which go to the individual advisor directly, including 1, like whether the advising company provides other services to the client, 2, amount of fees received by the advising company from the client, 3, policies and procedures of the advising company designed to prevent conflicts, 4, business or personal relationship of the individual consultant, members of the compensation committee, and 5, the stock ownership of the advisor. In a real-life example of how these rules might work, we had a client that's in a regulated industry, and its compensation used a national a consulting firm. That national consultant, however, also performed other work for the client related to its regulated business. So based on these enumerated factors, the compensation committee decided to change advisors. Now, it should be noted, however, that as long as a company conducts the required assessment of advisors' independence, the Act itself does not prohibit a committee from hiring an advisor that has been determined to not be independent. But of course, it's possible that the SEC may implement rules that require actual independence like the rules with respect to auditors. Page. As with me, a provision of the Act will have to wait until the SEC issues its rules with the specifics. In this case, the SEC has until July 2011 to issue the requirements to the exchanges, and it is currently requesting comments from the public. And with many other provisions of the Act, the SEC also has a couple of years to conduct a study and furnish a report on the use of compensation consultants. I guess I'll turn it back to Mary.
Thank you very much. Now we're going to turn to talk a little bit about some of the other compensation measures that are included in Dodd-Frank, in addition to the say-on-pay and golden parachute provisions that Justin spoke about, and the compensation committee and compensation advisor provisions that Jeff just spoke about. A new disclosure is required. We're going to focus on the pay versus performance disclosure requirement, the ratio of CEO pay to median employee pay, some requirements with respect to disclosure regarding hedging practices and policies, and turn to talk about clawbacks. All of these provisions require either SEC or stock exchange action. So, stay tuned on a lot of these, but I think there's some important information that can be gleaned for talking about them now in the context of the Act. So first is pay versus performance. The Act will require statement disclosure that shows the relationship between the executive compensation actually paid to the named executive officers and the financial performance of the company. As this presentation can be graphic, and many companies do this already. Are some disclosure requirements already, and a number of companies have gone beyond the line items of item 402 to really add some compensation disclosure, primarily around CEO compensation versus the performance of the company, but some go beyond and talk about all of the NEOs. So we'll need to see what regulations will be issued to frame this disclosure obligation. The second disclosure item, CEO pay as compared to median employee pay, has been an issue of fair concern to a number of companies. Small companies with a relatively small employee base, this not be an issue for them. But large companies with thousands of employees or hundreds of thousands of employees, multinational companies, companies with employees that get compensation from a variety of sources. All of this information is going to need to be captured, because the median pay under the Act, the median pay that needs to be compiled for all of the employees is the median pay using the Regulation SK Item 402 rules. So it's not just as simple as looking at one's W-2 income for the year for all employees, because, for example, the 402 rules would require identification of compensation that's earned for the fiscal year, not necessarily paid within that year. And it's important to make sure that you have consistency between the two pieces of compensation that you're comparing here. If you would follow 402 for the CEO but not follow it for the other employees, you have a mismatch there. It does, under Item 402, include all compensation, basically, other than pension earnings and above market interest. So, if significant parts of the employee base that get various benefits that are considered compensation. You're going to need to be able to compile all of that information. Then take the annual total compensation of the CEO and provide both figures and then the ratio of these amounts. A little bit later, and Jeff has already alluded to it, that the SEC has issued seeking comment from interested parties in the public in advance of proposing any regulations. And this is one area where they've gotten a lot of comment already. Some people asking questions, does this apply to part-time? Is it part-time and full-time? Is it temporary workers? Is it seasonal workers? And is there a way to reduce the burden that some folks feel this will really put on human resources and SEC reporting staff to compile the information in time for the proxy statement? As Jim talked a little bit about the pay votes, and he talked about the history that we have for some say-on-pay votes. Occidental Petroleum is something that I think is interesting to note. They had a voluntary, non-binding say-on-pay vote in last year's proxy statement that was actually rejected, got a no vote from the shareholders, and one of the identified topics identified for this particular company was the high rate of CEO pay as contrasted to other members of the team. So it's an issue of concern, and I think we're going to need to really monitor this and see where the regulations kind of take out in terms of this disclosure. Employee and director hedging practices and policies. Proxy statement disclosure is going to need to be made if hedging is permitted. And what the Act says with respect to that is, all directors or any employees, and it's not limited to officers, any employees permitted to purchase financial instruments, including prepaid variable forward contracts, swaps, collars, and exchange funds that are designed to hedge or offset any decrease in value that might arise from compensation-based equity awards or already owned shares held by those employees or directors. So it'd be important for companies to take a look at their code of conduct, take a look at their insider trading policies, and assess whether they need to add language that's consistent with this requirement, or whether their policies and practices, go into this. And this is, like the others, an area where the SEC rulemaking is anticipated. I'm going to turn this back over to Jeff to talk a bit about clawback policies.
Thanks, Mary. Okay, the Act, stock exchange listed companies must adopt a compensation recovery policy. In other words, a clawback policy. As Mary mentioned, this is another provision that requires SEC rulemaking before it's effective. But in general, there are three required elements. Three required elements of policy. First, the policy will be applicable if a company prepares an accounting restatement due to material non-compliance of the accounting rules. Second, the policy must apply to all current and former executive officers who receive incentive compensation during the 3 years preceding the restatement. Third, the compensation recovered would be incentive compensation that was received based on the erroneous data. Now, this sounds simple, but there are many, many details that need to be found by the SEC. And as with many other, this requirement is not applicable until the SEC and the exchanges have made the necessary rulemaking. Even though there appears to be no deadline in the Act, the SEC is expected to issue rules on this within the next year. On the page, you can see that these new Clawback rules will be different from the purpose of section like 304 of Sarbanes-Oxley. Under SOX, the Clawback only applies to CEOs and CFOs. It only applies if there is conduct. And also to whom the misconduct standard applies. In other words, if CFO cooked the books without the knowledge of the CEO, it is still uncertain whether the CEO would be subject to the clawback under SOX. In addition, the clawback under SOX is generally only enforceable by the SEC and does not give a private right of action to the company or its shareholders. And so, then the question is, what action, like right now, if we turn the page, there are many questions that will be answered until the SEC rules become available. But at least companies who are drafting compensation policies or entering into employment, separation, or other agreements with executive officers should at least reference the rules and bind executives to any future required policies. And you should identify the executive officers who will be subject to these new rules and review their existing compensation arrangements. It should be noted that the definition of executive officer is controlled by the SEC rules and is not necessarily who the company designates as an officer under its bylaws. So as a reminder, the SEC definition of executive officer includes the president, vice president in charge of a principal business unit, a division, or a function, sales or finance, or any other person who performs policy-making functions. I'll turn it back over to you.
Jeff, thank you very much. So as mentioned earlier, the SEC has a request for comments in advance of the proposed rulemaking. If you go on to the SEC website, you can see this request for comment, and the request covers all areas of Dodd-Frank where the SEC has some regulatory action that they're going to need to take. This is one small piece of that. You can almost feel a little sympathy for the SEC with all of the rulemaking they're going to need to make over the next year or so, particularly when you look at this SEC request for comment. It's divided into buckets on the website so that the comments are organized on the various decisions. I've taken a look at what comments have been received to date on the executive compensation and corporate governance provisions of the Act. And not surprisingly, number one on the list so far is the additional pay disclosures, particularly the CEO-employee pay ratio that I talked about a few minutes ago. Clawback policies are second on the list in terms of having some discussion of the kind of things Jeff alluded to. It's easy to say in the Dodd-Frank Act that the clawback will apply to the incentive compensation in excess of what had been received because of the restatement. But I think in reality we're going to find that it's not as simple as saying that causes the restatement will also be something that necessarily relates to performance measures or triggers for executive compensation that was paid. And some of the comments really dive into some of that. Compensation consultants and advisors and the independence criteria related to them to be promulgated is the third most frequent topic, with a range of interest depending obviously on the perspective of the commenter, but range from pushing the SEC to make some hard and fast rules regarding independence to a more disclosure-based topic, but most commenters are in favor of some regulatory action in the arena. And the fourth most to date is talking about the whole proxy process, which I'll talk about a little bit later at the end of this presentation today. But identifying concerns about the expanded influence of proxy advisory firms such as ISS and the impact that will have on these kind of compensation issues and disclosures. So before we leave the topic of executive compensation and turn to corporate governance, there's one more thing that covered financial institutions need to worry about under the Dodd-Frank Act. As Justin had talked about earlier in the presentation, recipients, financial institutions have had some experience with some of these requirements that will be new to non-financial institutions, but Dodd-Frank adds one more thing to them, and it will require by April of 2011 for federal banking regulators to issue regulations or guidelines to prohibit covered financial institutions from having any type of executive compensation arrangement that encourages the executives to take inappropriate risks. It also requires these federal banking regulators to set up a system to report disclosures regarding the incentive compensation arrangements to the specific banking regulator that covers that institution. The requirements will apply to compensation to any employee, director, or principal shareholder, and it will be enforced under Section 505 of Gramm-Leach-Bliley. So just one more thing for other financial institutions to worry about. I'm going to turn and talk about the core governance provisions of the Dodd-Frank Act. And Dodd-Frank, in the Senate and House versions, I think scared us all with to imposing requirements, for example, for majority election of directors in every uncontested election of directors, and that would apply to all public companies. There was significant concerns about the kind of the establishment of federal corporate law with something like that, and that did not survive in the final bill, so we won't need to talk about that anymore. What I will talk about in the corporate governance arena are the chair and CEO disclosure, but spend most of the time talking about the new final rule on shareholder access to proxy materials. And then close with a discussion of the SEC concept release on proxy plumbing issues. CEO and chair disclosure, Dodd-Frank requires companies to disclose whether and why or why not the company separates the chair and CEO roles. You can also talk about lead independent directors to the extent that that's applicable to the company. It requires rules which have to be issued by January 2011. Similarly to what Jeff talked about earlier, there's really something that doesn't need to be Dodd-Frank because it really is already covered by the proxy enhancement disclosure rules that were issued by the SEC in December 2009, effective in February 2010, and had proxy statements in the 2010 proxy season addressing this issue. The process rules, on the other hand, was shortly after the passage of Dodd-Frank when the final rule was issued on August 25th. There's a specific provision in Dodd-Frank that authorized the SEC to rules. They had issued proposed rules on this topic in June of 2009, but there was some discussion and controversy as to whether the SEC actually had the authority to issue these rules, and Dodd-Frank answered that question. Rules will apply to most companies. There is a 3-year moratorium for smaller reporting companies. Is new from the proposed rules. The SEC release talks about providing the ability to allow smaller reporting companies and, frankly, the rest of us in the SEC to see how this actually works in practice before applying these rules to companies for whom the financial burden of doing this may be more than the larger companies. This apply to controlled companies, apply to voluntary filers, and it does apply to investment companies. Only companies it will not apply to are referred to as debt-only companies that provide Exchange Act reporting disclosures because of debt securities. And the big changes from the proposed rules from June of 2009 to the final rules in August of 2010 are changes to the shareholder eligibility requirements, which I'll talk about in a few minutes. The establishment of a window period for these nominations to be made. Thus, the company will need to go by to elect the nominees for inclusion in the proxy materials when more than the maximum number of nominees are nominated. Removal of the potential liability for false and misleading statements that was in the proposed rules. And what this relates to is when nomination is made and placed in the company's proxy materials under this rule, the nominating shareholder has the ability to provide a paragraph up to 500 words regarding the nominee. And under the proposed rules, the company would have been liable under the Securities rules for false and misleading statements to the extent that it knew or had reason to know that the information was misleading, and that knew or had reason to know or knew standard is now gone from the final rule. As I mentioned, the 3-year moratorium for smaller reporting companies. So those are the biggest changes. If we look where these proxy access rules are going to fit within the parameter of other rules, the contest rules are still in full force and effect, and another alternative available to shareholders who may have the requisite, no intent on change of control of the company. One of the provisions of the rules does state that just because there's an ongoing proxy contest going on does not mean for that year you can get a pass on having to comply with these proxy access rules. So you could be in a situation where you have a proxy contest and you have nominations from other shareholders that you would have to deal with in your proxy materials. And the other piece of this is the shareholder proposal rules of SEC and proxy access rules. The vast majority of this rule deals with the whole proxy access process. But the second part, establishes that a shareholder can submit proposals on the director nomination process, and that those would need to be included. So, we'll talk in a few minutes about, that interplay as well. So the eligibility requirements now. The shareholder who wants to make a nomination, either alone or as part of a group, must hold at least 3% of the voting power of the stock, for election that can vote in the election of directors, and they must have held that stock for at least 3 years. If the shareholder has loaned shares to others, they are able to count those shares as long as they have the right to recall them and notify that they will in fact recall the shares and hold them in the event that the company is the shareholder that nominee is going to be placed in the proxy materials. There is no requirement for the nominating shareholder to have to attend the shareholder meeting. This change to the 3% in 3 years is a marked difference from the rules, which had staggered criteria based on the size of the company and also had a 1-year holding requirement instead of the 3 years. So, may help reduce, at least initially, the number of folks who will be taking advantage of these proxy access rules. The release has some interesting statistics that show the ownership percentage of public companies, and if you're interested in that, I refer you to the release. The shareholder has to hold both voting and investment control of the shares. And there is a class vote. If one group of shares, one class of shares is entitled to vote for one position, you don't have to count that director in determining the size of the board. Second biggest requirement we'll talk about here is how many people can be nominated by shareholders under this process. The requirement is the greater of 1 or 25% of the size of the board, and that is the size of the total board, subject to the specific class vote that I talked about a minute ago. So, for an example, if you have a 9-member board that's staggered in 3 years, as Justin used his example, either shareholders could nominate up to 2 director candidates, nominees for that particular election. And with a 9-member board staggered, you would have 3 slots available. So you can see that it really does have an impact on companies with staggered boards in terms of how many how many nominees there will be. The company will be required to include the nominees in its proxy statement, including any of the supporting information and the proxy card for the annual meeting. You identify on the proxy card the nominees are company nominees and which are shareholder nominees, but you cannot combine the company nominees in one group and give the shareholders the ability to vote, in essence, for the management slate, but you can identify them. No trigger events for the proxy access rules. Prior proposals of the SEC had said you needed to have a shareholder proposal that was passed or, some other trigger events. There's no opt-in or opt-out of these. These are applicable to all the companies that are required to comply. As I mentioned, the rule will continue to apply even if there's an ongoing proxy content. And there's no restriction on the use of the rules by the same shareholder in subsequent years. So if a shareholder nominates someone and they're not elected by the board, there's no period of time where they would not be able to renominate that same candidate. So nominees, what do they need to meet? They need to meet the stock exchange and SEC objective independence standards. If there are subjective standards from either the stock exchange or the SEC, those will not need to be complied with. They have to comply with any other applicable federal or state laws. For the active independence standards for investment companies, what they have to certify to is that they meet the interested person standard for investment companies under 2A19 of the Investment Company Act. In the 14N schedule, which is what the nominating shareholder is going to file, they have to certify to the best of the knowledge of the nominating shareholder whether the candidate meets the director qualifications set forth in the company's governing documents. This is not disqualification of the nominee. If you don't meet the director qualifications set forth, what SEC has said is that the company can have proxy statement disclosure to describe what qualifications they don't meet. 14A11 is the principal rule related to these nominations in Schedule 14N. So the Schedule 14N sets forth all of the requirements that the nominating shareholder must meet and the various certifications they need to make, they need to provide in terms of stock ownership. And Schedule 14Ns will be filed with SEC and delivered to the company within the window period that I'll talk about in a minute. The company needs to do, if once they receive the nominations, is evaluate whether the nomination complies with Rule 14A11 and then use the no action process if they want to reject a nomination. The window period is the time period from 150 to 120 days before the anniversary of the mailing date for last year's proxy. This, in my view, was one of the best changes between the proposed rule and the final rule. Because otherwise, it was a kind of a first-to-file proposal, so that the company had no ability to put any restrictions on the early nature of when proposals might come in. Likely that these are going to be effective for most annual meetings in 2011. The Proxy Access Rules are going to be effective 6 days after publication in the Federal Register. They have not yet been published in the Federal Register. But the SEC release says that if the entire window period occurs in full before the effective date, then these rules will not apply to that particular company for 2011. If any portion of this period, this 150 to 120 day before period, arises after the effective date, then the rules will apply. So it is important to look at your annual reporting schedule and incorporate this change to make sure that you're paying attention to it. You want to look at your governing documents and assess if you want to add any qualifications. Regulated industries in particular might want to look at this. You need to make sure that qualifications apply to all director nominees. And you might want to look at your bylaw provisions and see how these final rules interact with nominating procedures that may be set forth. Are they stricter? Do you want to change them? You will have disclosure, but it's things you can look at now. You also have to remain aware of the interplay with the revisions to Rule 14.818 about shareholder proposals on the director nominating process. Those standards for a shareholder to make those kind of proposals much lower, either $2,000 worth of securities and held them for 1 year. So it's possible that the shareholder proposals may be submitted to companies to provide more favorable provisions with respect to the director nomination process in future years. In that case, the only way that the company could reject those proposals, or if that proposal would disqualify a nominee from standing for election, move a director from office before his or her term expires, question the competence, business judgment, or character of one or more of the nominees or directors, seek to put a specific person on the ballot, or otherwise could affect the outcome of the upcoming election. So it's important to keep this in mind as we prepare for potential shareholder nominations. So I'd like to close by talking a little bit about the SEC concept release. This came out a few months ago. The SEC is looking for input on, referred to as proxy plumbing issues, the ability of companies to communicate with shareholders, the participation of shareholders in processes for public companies, the role of proxy advisory firms such as ISS. I've listed on the slide the 3 general topics that the release covers: the accuracy, transparency, and efficiency of the proxy voting system. This relates to issues such as the decline in retail shareholder voting with the advent of electronic delivery of proxy materials and the like. Communications with shareholders relates to the OBO/NOBO lists, the inability of brokers to without direction in the process of both brokers and companies to be able to communicate with their shareholders with respect to election issues, the relationship between voting power and economic interest with things like the loaning of securities. One of the release issues that is interesting that could impact companies specifically is, they want to comment on whether they should establish dual record dates so that you have one record date for who you have to mail the proxy materials to and another record date for who actually gets to vote in the annual meeting. So SEC concept release is included on the SEC website, and if you have an interest in that, I would recommend it to you. What we have to talk about today on topic, I think I should have told you this in the beginning, but there is an ability on the screen for you to send us questions. Obviously, we don't have time today to answer them, but if you want to send us a question, we will get back to you. And this presentation will be provided on our website under our Dodd-Frank Task Force, and we'll give a link to this if you'd like to listen to our voices again. So on behalf of Justin and Jeff and Ballard Spahr, we thank you very much for participating. Thank you.